Hi, everybody. This is TJ from urlaw.org, and we've got another success story we want to tell you about. And we're going to be introducing you to our associate instructor here in a moment. And he was sitting in and giving a little bit of assistance to one of our members. Normally, we're not able to be in the courtroom, but this is a rather interesting one where we got to observe it firsthand. I wanted to describe to you, because this is part of a process that we use called the slam dunk. Slam dunk is for criminal, not civil cases, and particularly those that are in pre-trial, so they haven't gone too far down the road, haven't already done a plea, haven't gone to jail, you haven't even gone to trial yet, you're really just early on in the process. So here at urlaw.org, our purpose is to help people get themselves better prepared and to deal with these kind of situations. When people decide to upgrade and do our Slam Dunk program, we teach them some key things that they need to do in a criminal case. And by the way, let me say this is not legal advice. We're just trying to show you what's out there, what we've experienced, what we see, and by sharing that with people, we find that they have substantially better outcomes with their criminal cases. Now, what this is not for is somebody who is outright and intentionally harmed someone financially, physically, and that sort of thing. It's not for that purpose. It's one of these sort of what we call paper crimes, simply something that where there wasn't a harmed outcome, and we typically try to stay away from situations where you're endangering somebody, but sometimes we do. It's a gray area when you're dealing with that. So one of the elements we do in the Slam Dunk is something called a Bill of Particulars, or a BOP, sometimes we call it. That's one part of it. And it's nothing generic you'll find out there. It's very unique and customized to what we do. And we try to get that in very early in the process. And then we deal with issues about counsel and speedy trial and that sort of thing. And more of that's what we train you on in the course. We're not going to tell you all of that here. But the goal of the Slam Dunk is to, number one, save you a ton of money on legal costs, because most attorneys are going to want $10,000, $15,000, $20,000 just to take on a criminal case. Or if you do have an attorney, to reduce the cost substantially. That's one thing it can accomplish. Number two, you may not end up having to pay an attorney at all. We've seen cases go 3 or 4 years and not a penny of legal costs outside of just getting the training was incurred. The goal is to get something dismissed or at least reduced to a very harmless, we call it getting out the door charge. And because you might have gotten yourself into something, and if you can get out there with minimal costs, that's a good thing. But ultimately, we'd like to get it dismissed as well. If not, at least create an appealable case, okay? And we deal with many different kinds of cases. We've had clients come to us with federal, state, a huge variety of things. And in this particular case that Lauren's got here is that it's a matter that involves a DUI, but not just a DUI, a repeat offender DUI, which normally we're very cautious about even getting involved with, because sometimes somebody's actually engaged in dangerous behavior. But we're hoping that they can learn, repent, and stop doing that. And in this case, they got away without harming anyone. So if you would you tell us basically what the charge was, what happened, and then what happened with you going into court here last week?
Okay, so this is...
what you witnessed. You're a witness of.
Yeah, I'm a witness of. This was his third DUI. In this particular one, they stopped him for DUI. He was driving on a suspended license. We got a ticket for reckless driving. We had a ticket for 2 other things that kind of slipped my mind. He actually had 5 tickets, but the 2 that they were most concerned with were the driving without on a suspended license and DUI.
To be able to drive to make his living, so he's risking a lot by doing that. That's for sure.
He has property all over the place. He has real estate all over the place, so he has to travel some days in excess of 200 miles in one direction. So he really needs his license to make a living.
So if somebody's done those kind of things with those multiple charges, is probably facing some pretty good jail time and fines. So what basically instead, though, happened, you gave the member a direction to use a bill of particulars. He didn't do particularly well in court. We hope he'd had a little more preparation, but, in spite of that, you were able to kind of nudge him along. Tell us what happened in the court.
Okay, so what he was looking at, they initially wanted to put him in jail for a year. They wanted a $5,000 fine and a 5-year probation. That's what was on the table. So we gave him bill of particulars, He submitted them to the prosecution. He's going in for basically it's a pretrial. And he goes in and they ask him about pleading and all that. The guy's not very strong. I'll just call him Sam at this point. That's not his real name, but just for this sake of argument, we'll call him Sam. Sam says, the judge says, well, we're going to have a hearing today. And he says, I got my bill of particulars in, and I need to know the nature and cause. And so the judge comes back and says, well, we're going to have a hearing today. And he repeated it again. He said, I need to answer the bill of particulars in writing from the prosecution so that I can understand the nature and cause so we can move forward. I counted it. He said that 8 times. The judge kept saying he was moving forward, but he wouldn't move forward because every time the judge tried to move forward, he said, well, I don't have an answer to my bill of particulars, and I need to answer the bill of particulars, and I need to understand the nature and cause before we can move forward.
Sixth Amendment. Anybody out there is listening, go read the Sixth Amendment really carefully. There's 3 major parts to it. So he's asking for a Sixth Amendment right to be enforced. Go ahead.
So this goes on, the 8 times, and on the 9th time, I finally had to interject because the judge kept trying to get him to take the public defender, and he said, I can't take the public defender because I don't know the nature and cause. I don't have my bill of particulars signed. I don't have the written answers to my bill of particulars on a point-by-point basis. I can't go forward. So I actually interject, and I know this is crazy, but I actually interject, and the judge was stuck. He couldn't go anywhere. So I said, hey, maybe he wants to talk to the public defender. And I kind of directed him and said, hey, we'll talk to the public defender. So they go into the room, and we go in there, and she pulls out a chart, and she's showing you, these are 3 strikes, and you could, this could be considered habitual, which adds more time to it. And here's what's on the table. And so finally she says, wait a minute, you've got a driving under suspension. I have to check with the judge to see if he's going to enforce that. So she goes out, speaks to the judge. She comes back and says, oh, no, he's not going to do the suspension, driving under suspension. He's not going to do the speeding. He's not going to do the reckless driving. He's not going to do the reckless endangerment, which was the other one. We're not going to do any of those.
Wow. So the judge is looking for a way out.
Unbelievable, he's looking for a way out. So we go through that. We go back in, and I'm sitting in the conference room with Sam and the PD, and I'm trying to explain what everything means to him so he grasps it in the whole 9 yards because I'm an ADA, American Disability Advocate, and just trying to make sure he understands it. And when we come back out, let me back up. We had another friend with us who was in the courtroom while we were in the conference room, and the policeman looks at the bill of particulars and said, what's that, something you got off the internet? And these are the exact words of the prosecutor. Prosecutor says, no, this isn't something he got off the internet. This is something that someone has done for him. And this is no joke. We're going to have to deal with this.
Yeah.
So, we come back out, and when we come back out, I see a guy in the front row in a gray T-shirt. I'm like, who is this guy? Anyway, I thought he was going to be a witness. Come to find out, this guy is the sheriff of that county, and he's saying, oh, man, the judge really appreciates you being here and helping to explain that. And I'm like, what is this about? But the point of this conversation is, ladies and gentlemen, is they don't want to deal with the bill of particulars, so we end up getting
not the one we
offered him at the end. Yeah, at the end of the day, they end up offering him 10 days in jail, 1 year probation, and a $500 fine. So that's a long way from a year.
Let's make sure everybody hears this. So he was facing a year or more, 5,000 suspension and all that. A lot of bad charges. I mean, these are things that would be on his record that would really harm him in the future. And to a what?
Okay, so what they ended up, the initial offer is 10 days in jail, 1 year probation, and a $500 fine.
That sounds better.
Now, what he would have been 1 year in jail, 5 years probation, and
probably
a $5,000 fine
in legal fees on top of that.
And there were some other legal fees.
No, I mean, he would have been paying $15,000 or $20,000 in legal fees by the time he got through it all. Yep.
And I say to everybody, this guy wasn't very strong. I mean, we listened to this thing 2 or 3 times. He didn't have enough confidence. One of the things about the bill of particulars or being in that environment, everybody has to stand their own ground, and you got to stand on your square. If he would have been a little bit stronger, he could have handled this whole thing himself. But I interjected just a little bit, just so he could, get his arms around it.
Yeah.
And the judge was so happy to get off the hot seat, he didn't know what to do.
Yeah, for considering it's the third time, he really got off. I've never heard of anybody getting off that easy with those kind of charges multiple times. And again, we're really stressing to the client that he goes and cleans up his act too. This isn't about getting away with something. This is about getting justice, getting equity, and getting something resolved in a harmless way. And I've never, the fact they didn't force him to come back in, go through the whole process, they just threw that deal out there really quick, shows you that the leverage of doing things right. And the other people in the court respected that. They respect that you come in with standing and leverage versus cowering down and just sucking up to the whole system. They don't like, they like people that stand up, not in the sense that he wasn't fighting, he was just asking. And there's a big difference between running into court like a lot of sovereigns do and start making claims, I'm a this and I'm a that and I glow in the dark. It's, I have an inquiry and I want you to give me I need to get this dealt with first so that we can proceed. I need to understand the nature and cause. It says in the Sixth Amendment, you have to understand the nature and cause. And what we do is we use that tool and several others, don't we, that deals with that Sixth Amendment issue. There's several tools that we use in the process. If it goes further, we're finding is quite often, and not every time, they come right back out with something that's very palatable and make a much better offer for everybody to get out of there, because they don't want to address what we bring up in these documents. It just shows you, because it shows fundamentally what it does. It fundamentally shows the big, huge flaws in our legal system. And if they had to answer them, everybody would know about it. It's not that it's a big secret. It's just that people don't know the right questions to ask. And so we try to teach people at yourlaw.org, how to ask good questions and how to get a better result. And hopefully do it without spending too much money on legal fees. We're not saying, we poo-poo all lawyers, but the fact is there's so much more power in what you can do on your own, speaking your own words, than what you can do with somebody else speaking them for you, because they won't even say the words. They won't even ask for these documents, yet you can. And so that's just an example in a criminal case what we can do. Any other final comments?
No final comments. That covers it. It was a success. Big success,
yeah,
and he was relieved.
He got away, and he's not done. We're still going to continue to press for that document and a couple of others, aren't we? Even though before we accept that offer, before he accepts that offer, I should say, we're not we, but he. The idea being that they even make it a better, sweeter deal, because typically they come back with a counter that's even less.
Right.
We'd like to see it dropped, but a reasonably multiple case like this where he's done it multiple times, he can't expect that, because there has to be some acceptance of personal responsibility. But they give him a minimal impact and give him a chance to clean up his act. That's a good thing for everybody. Okay.
Great outcome.
Yeah, great outcome. Good job. And again, not everybody has the benefit of having someone there to sort of nudge them. Usually we have a little more time to prepare, and they do it themselves just fine. It's a simple thing to stick to. Well, thank you. And everybody else that's interested, get over to yourlaw.org, find out about our memberships. We have free membership, premium membership, and then we have private coaching training packages, which is the Slam Dunk is, as an option. And we'll see you over there.